Hello, I'm Gina Chevalier, your Florida estate planning, probate, and guardianship attorney. And today I'd like to talk to you about planning for family members with special needs. So in Florida, there are many different ways that we can plan for family members that have special needs. You can do it through your trust. You can do it through your will. We can do a separate standalone trust for a supplemental needs person. Or there are other tools that we can use in Florida, including ABLE accounts, guardianships, etc. I'm going to go through some of these for you. The differences are planning for yourself versus planning for the individual. So you can do your own estate planning in which you create a trust that has either a supplemental needs provision for a family member, a sub-trust within that trust, or you can create a supplemental needs trust within your will. Now, the difference between those two is the will has to go through probate, your trust does not. So your supplemental needs trust that you create for somebody else will help them for the rest of their life. It can be in your own documents, it can be in your will, etc. But what happens if this individual is turning 18 and now you need to make decisions for them? Well, in Florida, we have a concept called guardianship. And that's something that can be done through the courts in order to make sure that you are able to be the sole decision maker for your child or your family member. Guardianship isn't for everyone, though. It can be very intrusive. The courts require annual reports, recommendations for the treatment, background searches on the individual. So what are the other things that we might be able to do? One of the things is something called guardian advocacy. A guardian advocacy is not the same thing as a guardianship because you don't declare the person incapacitated. So if you have someone that has some needs, but not all needs that need to be taken away, so maybe they can't handle their financial affairs, maybe they can't contract, but you don't want to declare them incapacitated because you want to get them into a program or something that requires that they not be declared incompetent. So that is where the guardianship advocacy comes in. So I know I've just unloaded a lot of information, and this can be a very stressful and difficult time for you. I know that you're dealing with emotional anxiety, what is going to happen to your family, but that's where we come in. We're here to help you and guide you through this process. Give our office a call when you're ready.